Welcome, everyone. This lecture is the first part of law and development. I would like to begin with this question: what is law and development? Law and development aims to explain the interrelationships between law on the one hand, development on the other. Law and development refers to various studies, analytical approaches, and practical projects that concern the general or specific aspects of this relationship. There are three perspectives to look at the relationship between law and development. The first perspective is that law is merely a vehicle through which a chosen policy is implemented to achieve development, however development is defined. So let's suppose that a development objective is to improve land usage by setting up an effective land registry. In this case, analytical focus is on policy, the policy that improves land usage by setting up a land registry, rather than law. So in this perspective, law happens to be in place as a device to implement the policy, and it's not subject to a separate analysis. The law has only limited significance. The second perspective is that law, as well as policy, is relevant to development and is subject to a separate analysis. So going back to the previous example, there are laws that set up land registries around the world. These laws are either identical or very similar. Nonetheless, their impact are very different from place to place. In some places, the land registries set up by the laws work very well, and some other places, they do not. Although, again, the laws that set up land registry and the policy of improving land usage by setting up land registries are identical or similar. So the analytical focus is on the impact of law and relevant elements such as institutions and socioeconomic conditions. And it is not assumed that law successfully implements the policy that it advances. So the second approach is asking why in some places a certain law operates very well and facilitates and supports the policy effectively, and why in some other places the seemingly the same or similar laws do not do so. So law is subject of assessment and analysis. And we study the impact of law in the second approach. Third approach is that the existence of rational law or a governance system based on law, called the rule of law, constitutes an element of development, regardless of its specific impact on economy and society. So example would be the present SDGs, the Sustainable Development Goals that include the rule of law among the development targets. So in this perspective, the development of law or the rule of law in itself is development object. Whether or not the law so developed actually improves the economy or meets other social development objectives. The law in itself, the rule of law in itself, in this approach, is development. So which of these three perspectives to adopt? There seems to be a problem with the first approach. As we have seen, the same or similar policies, such as setting up land registries and improving land usage, supported by law, these policies very effective in some places, and in some other places, the same or similar policy does not work very well. Although the laws that support this policy is either identical or very similar. So the law needs to be assessed and its impact needs to be analyzed separately. What about the second and third approaches? In the second approach, we study the impact of law. And the third approach, law is considered an object of itself. I believe the second and third approaches are consistent and compatible because law can be both an object and also means to support economic and social development, as we will see throughout this course. Law and development are also distinguishable from other related areas. I'm sure many of you have heard law and economics. The law and economics assess the economic efficiency of the law. So whether or not a certain law is economically efficient. The law and economics tends to emphasize on microeconomic issues, but law and development emphasis tends to be macroeconomic issues, such as the overall improvement of the economy or industrial facilitation as a whole. So the emphasis is a bit different. Law and development is also distinguishable from law and society. The law and society studies the impact of law on society more broadly, but without focus on development issues. And law and development, the emphasis is on development. In the study of law and development, there are operative concepts such as law, legal frameworks, and institutions. Law in the context of law and development refers to a body of rules of action or conduct prescribed by controlling authority and having binding legal force. A specific rule or a set of rules binding on the members of society. So in the context of law and development, law might be a little bit broader than what is officially recognized in society. So example would be statutes, constitutions, regulations, ordinances, case law, and even customary law. But there is some distinction between law in the context of law and development and non-legal orders. So not all of the community ordering, non-legal orders, would be considered to be the law in the context of law and development. The point of distinction is perhaps whether or not opinio juris exists with respect to a particular order. So for example, administrative guidance prevailed in the development of South Korea and Japan back in the 60s through the 80s. Now, administrative guidance is not a legal order, but a recommendation, instruction from the government. Normally, administrative guidance is issued to corporations and businesses. Again, it's not binding legal order. But most corporations and businesses in South Korea and Japan followed administrative guidance, again, from 1960s through the 80s, with recognition of the role of the government in the economy, even without opinio juris, the sense of law. So perhaps administrative guidance is not considered law in the context of law and development. The operative concepts also include legal frameworks and institutions. Legal frameworks refers to frameworks in which law is organized, including regulatory structures and legal systems. So what we call common law systems and civil law systems are examples of these legal frameworks. The impact of law could vary under different legal frameworks. So let's say a particular legal rule is in the form of standalone statute with possibly some enforcement provisions of itself, or it could be in a form of regulation subject to the control of a higher level statute. And the impact of this legal order could be different depending on whether it is in the form of standalone statute with enforcement provision of itself, or a regulation subject to the control of another statute that may have different or weaker form of enforcement provisions. The legal frameworks may also determine the adaptability of a law. So the adoption of a statute referencing fiduciary duty or constructive trust, and these legal concepts, fiduciary duty or constructive trust, are developed in common law. But if a civil law country wishes to adopt a statute with the concepts developed in common law, the effectiveness statute might be limited because its legal system may not have these legal concepts broadly across the board. With respect to legal frameworks, there's an interesting theory called the legal origins theory. This theory claims superiority of the common law system over the civil law system. And the claimed superiority includes a broader liberty and freedom in common law versus collective rights and greater government activism in the civil law. And this superiority of common law is translated into a better economic development results. The question is whether or not this theory is consistent with the development history. So if you look at some of the most successful developing countries in the past, such as South Korea, Taiwan, Chile, and China, these are all civil law countries. Now, Singapore and Hong Kong had a common law system, but the government showed state activism, which this theory prescribed as a characteristic of the inferior common civil law system. So again, despite the theory, some of the most successful developing countries in the past, again, including South Korea, Taiwan, Chile, and China, were all civil law countries. Even a successful common law developing country in the past, such as Singapore, showed great state activism, the government activism, which the theory called characteristics of relatively inferior civil law system. Institutions is also an important operative concept in law and development. Institutions refer to organizations, norms, and practices related to the adoption, implementation, and enforcement of law. So effective prosecution system, prosecutorial service would be an example of such institutions. Importance of institutions is obvious. In criminal law, effective prosecutorial service is important to enhance social peace and stability. And independent judiciary is also important in resolving economic and social disputes in society. And the laws that protect the property rights and affordable and reliable land registration system, these institutions will be imperative to ensure the success. The emphasis of institutions in the context of economic development has been explained by many, including Douglas North. And then scholars have advocated a cluster of institutions important to economic growth. And those institutions include those that provide some constraints on government expropriation, independent judiciary, property rights enforcement mechanism, and institutions providing equal access to education and civil liberties. So all these are considered a cluster of institutions deemed important for development. And there are also market-supporting institutions, property rights, regulatory institutions, the institutions for macroeconomic stabilization, such as working central banks, institutions of social insurance. So in the US, Social Security Administration will be an example. In other countries, there are similar institutions that provide social insurance. And also institutions of conflict management, and the most important institutions that fulfill that role will be the court of law. Development is also a key concept in law and development. The development can be defined as a progressive transformation of the economy and society, or simply economic and social progress. And then there's a question of what constitutes economic and social progress. Back in the 50s or 60s and perhaps 70s, development meant economic growth. But now the concept has been expanded, and now the development means more holistic concepts, including non-economic values such as political participation, right to property, gender equality, access to a clean and safe environment, and the rule of law. So Amartya Sen advocated development as freedom. And his concept, the development meant political freedom, economic choice, and protection from abject poverty. UNDP also developed a holistic notion of development. And then it advocated the concept of human development. It consists of elements such as those that directly enhance human abilities, long and healthy life, knowledge, and decent standard of living. So both social, political, and economic progress. This holistic approach has been adopted broadly by others, such as World Bank's comprehensive development frameworks, and the UN's 17 SDGs also include holistic views of development. But there are social and economic constraints inhibiting the realization of the holistic goals of development. What are those social and economic constraints? For example, securing a clean and safe environment requires economic resources. The rule of law necessitates trained legal professionals, an efficient court system, and reliable enforcement mechanisms. So the question of development is intimately related to securing the resources to realize those goals. The resource constraints means that there is a need for sequencing and prioritizing the development goals. The successful development history of East Asia suggests the importance of sequencing and prioritization. So in South Korea, Taiwan, and Singapore, they focused on economic development from the 60s through 80s. When they have achieved a level of economic development and secured economic resources, they were able to use those resources to promote non-economic social agenda, such as the rule of law, and social and environmental development goals. So what are the interrelations between economic and social development? Non-economic social development affects economic development. So if a country adopts export promotion strategy to develop economy and industries, those in manufacture would benefit more from, say, those in agriculture areas. So distributive effect will be different, and depending on the social development objective, social progress goal, if a country values distribution more than overall economic growth, then it also affects economic policy. Other progress in social development, such as improvement of gender equality, can positively impact on economic development by raising economic participation of both genders. There is a strong need for economic development today. There is the reality of poverty that continues to exist. So according to a statistics, 25% of the world population still lives under $3.2 a day. Economic development brings resources to fulfill non-economic goals. And then co-promotion of economic and social development is possible where no resource constraint is present. So in places where the resources are constrained, it is difficult to promote social development goals. In order to improve safety for women in society, the bringing up a strong penal code against offenses against women is not sufficient. There has to be effective police force, there has to be effective prosecutorial service, and the court system and correction facilities all cost resources. So it's one reason why we have to emphasize economic development, at least the initial stages of economic development. But even during this time, the social development goals do not have to be set aside, particularly where the resource constraint will not inhibit on the promotion of social development goals. Not all of the social development goals require economic resources to a similar degree or extent. So there can be a room for promoting both economic and social development in a way that doesn't create serious resource constraints. There is also a difficulty in identifying a social progress or development in the context of law and development. Despite the existence of values and priorities claimed as universal, such as fundamental human rights of a political and civil nature, what is viewed as a political and social progress is a much broader question that lacks a cross-cultural consensus. So in the United States, there was a Supreme Court decision that mandates the approval of same-sex marriage by all states. But there has been substantial controversy whether or not it represents social progress in the United States. So social development agenda often lacks a cross-cultural consensus. Given the difficulty, the social development or social progress could be defined as a transformation of a society that fulfills a particular value or set of values shared by the majority of a society, where these values are not identical across societies with varied cultural and ideological orientations. What it means is that when it comes to social development or social progress, different societies may have different goals and different views about progress. and that needs to be respected. So in our study of law and development, the approach is descriptive and analytical rather than prescriptive and imposing. There is also a question of expanding the concept of development. Traditionally, law and development is associated with improving the economic and social well-being in developing countries. But there is a room for the application of law and development approaches to address economic problems in developed countries as well, such as the United States. The economic realities of developed countries tend to justify this expansion. There has been widening income gaps among individual citizens and geographical regions within developed countries such as the United States. There has been stagnant economic growth, deepening income gaps, and accompanying unemployment and the institutional incapacity to deal with these issues within developed countries. These issues go beyond the cyclical economic issues once considered a normalcy in developed countries. So these problems, widening income gaps, economic stagnation, polarization in developed countries, resemble the chronic economic problems of the developing world. It renders the law and development approaches relevant to the economic issues in developing countries. So it suggests that the law and development approaches is relevant to economic issues in developed countries, as the problems now resemble the chronic economic issues in the developing world. There are some political issues, though, in addressing the existing economic gaps within developed countries. And the question is whether the law and development approaches, i.e., assisting with development through legal and institutional means, would that be consistent with the political and legal traditions of developed countries? So in the United States, for example, the economic development issues tend to be considered local rather than national issues. So then this approach to address these economic issues with the adjustment of the laws and institutions on a national scale, would this be consistent with the political traditions of the United States based upon the federalism, i.e., the local issues are dealt with by local governments and authorities, not by the national governments? And the question then is, can economic issues be left to regional and local communities? Well, there are resource issues. More often than not, the regional and local communities, even in the United States, lack resources to effectively support industries and economy as a whole. There is also ideological preference for small government. So this idea that the government facilitates and supports economic progress in the country with adjustment of laws and legal institutions might not be consistent always with this preference for small government. And that is related to a deeper question about the appropriate role of the state in general. The second part of this lecture pertains to the general theory of law and development. There has not been a comprehensive theoretical framework that sets the conceptual parameters of law and development and analyzes the causal mechanisms by which law impacts development. So we have notions that there is an impact of law on our economic and social development goals. But then we've never had a theory that explain systematically how then law affects our economic and social development. So the general theory of law and development has been developed to meet this need. And it is an academic exercise. So the theory attempts to explain how law impacts development, but also there's a scope to apply this theory to resolve practical questions. So specifically how law should be designed to improve its economic development goals or social development agenda. Actually, the first part of this lecture has addressed the first part of the theory. So we have discussed the conceptual parameters of law and development. And now we're ready to discuss the second part, which is the regulatory impact mechanisms. Again, the mechanisms by which the law impacts development. As we have seen, the identical laws do not result in the same outcome. We have different outcomes. So the laws that facilitate and manage the land registries, sometimes these laws work effectively, and some other places, these laws do not work very well. And the reason is there are elements that affect the operation and the impact of law. And we need to understand what these elements are. So there is a need to clarify the mechanisms by which law impacts development. And this theory explains these mechanisms under three analytical categories, which include regulatory design, regulatory compliance, and quality of implementation. So the first analytical step to assess the impact of law is to analyze the law's regulatory design. Regulatory design refers to how optimally law is designed to achieve its regulatory objective. And there are three sub-elements. One is anticipated policy outcome. The second sub-element is an organization of law, legal frameworks and institutions called LFIs. And the third sub-element is adaptability of law to socioeconomic conditions. And analysis has to be conducted against a well-defined development objective. So if a development objective is overall economic growth, then the law that tends to create more even income distribution will not be meeting this development objective. On the other hand, if the development objective is overall economic growth, even if it creates a broader income gaps, then the law, on the other hand, that aims to improve income distribution will not be meeting this objective. So when the assessment is done, a development objective has to be clarified first. So given that, we can try the first element, which is anticipated policy outcome. The anticipated policy outcome is the specific outcomes that are anticipated as a result of the implementation of policies. So there are examples of policies promoted by law. So the law that authorizes the government to grant subsidies to a particular industry has the objective of promoting that industry. So let's say that South Korean government back in the 60s authorizes itself by law to grant substantial subsidies to steel industry, hypothetically, then the policy promoted by law is to facilitate and improve South Korea's steel industry. Anticipated policy outcome is not the same as pronounced regulatory objective. What it means is that a law may state its objective. So by, again, creating a law that facilitates steel industry, it'll have a pronounced regulatory objective of promoting steel industry. But it doesn't mean that the pronounced regulatory objective will become an anticipated policy outcome. Let's take an example. So the law that authorizes the US government to provide relief checks to the US population to help them overcome economic problems associated with COVID-19. So a lot of Americans receive paychecks, checks by the government to help them with their household expenses. So the pronounced regulatory objective in this case is to aid US households with their expenses during COVID-19, right? But what can be anticipated by this policy, the policy to give checks to the US households? Not only it increases income for US households who receive those checks, but also an inflation can be expected because then now the production stays the same, but the government provides more checks, and that can raise inflation throughout the society. And that's in fact what happened after large disbursement of funds from the government to US households. Inflation is not pronounced regulatory objective, but it is part of anticipated policy outcome from those policy to provide checks to US households. Then how do we figure out anticipated policy outcome? For this, it's necessary to use social science analysis and methodologies. So economics will be an important tool. Other social science disciplines like political science, anthropology, statistics will have to be employed to assess what would be the anticipated policy outcome of a given law. And then its analysis is inexact in nature. So for example, what facilitates economic development in early stages of developing country? Scholars may have different views of it. So neoliberal scholars might argue that minimizing governmental intervention will be the key for economic development. Whereas those who advocate active state involvement in industrial development would argue that the laws that actively grant assistance and regulate industrial support will be important. So reference to social science disciplines will not automatically provide answers as to what anticipated policy outcome will be, and there will be controversy. What further complicates the issue is that the anticipated policy outcome might be different in accordance with, in the case of economic development, stages of economic development. So if you refer to a successful economic development history in East Asia, such as South Korea, Taiwan, and Singapore, in the 60s through 70s and perhaps early 80s, the governments in these countries actively supported particular industries with substantial state control. But beginning in the mid to late 1980s, these countries started to liberalize the economy and then gave more autonomy to private sector and reduced state control, again, resulting in continuing economic development, the transition from strong state control, which was considered effective and instrumental to bringing those economies from poverty to mid-level advanced industrial economies by the 80s. And then from the 80s, relaxing state control and giving more autonomy to private sector now, which has been reinforced thanks to development in the preceding period. And this liberalization facilitated further economic development in these countries. So the anticipated policy outcome could be different according to the stages in which the economy, in this case, is situated. So in the case of economic development in East Asia, a transition was observed from state control to increased market autonomy as the economy is successfully developed. And we call that the marriage between state and market. The second sub-element that we need to assess the impact of law in regulatory design will be organization of LFIs. Law may not be effective absent a suitable legal framework and effective institutional arrangements. So in order to protect property rights and thereby increasing economic efficiency, it's not sufficient to have a law that purports to protect individual property rights. So land registration is one important way to protect property rights. But as we have seen, the law that tries to protect individual property right may not be as effective without suitable legal framework and effective institution, such as law enforcement. Those who interfere with somebody else's property right should be effectively controlled and sanctioned. And that will not be possible without an effective institutional arrangement. Inconsistent LFI would also diminish the impact of law. So, for example, a law that approves the government to expropriate private land without due process, it will be inconsistent with the legal frameworks and institutional arrangements already in place to protect property rights. The third sub-element is adaptability to socioeconomic conditions. Socioeconomic conditions refers to a range of social, political, economic, and cultural conditions that are essential to the successful operation of law. So, for example, the adoption of a law that authorizes charging an interest in a predominantly Islam country will not be effective because such a law will be inconsistent with the religious belief of a majority population that prohibits the charging of an interest in Islamic faith. Another example would be adoption of a certain Korean laws stipulating the code of conduct for public officials and mandating releasing information to the public. These might be the good laws, but in order to effectively implement such laws, you'll have to have a system in place. You'll have to have a frameworks in place that allows sharing information and which raises a respect for such a code of conduct. Without these socioeconomic conditions, the law that mandates these things might not be as effective. Changes of socioeconomic conditions may also result in the change of law. So in the United States, for example, a development of financial industry in the early 20th century necessitated an enactment of the Security Act, which established the Securities and Exchange Commission. We call that the SEC. And the SEC monitors the securities industry and enforces laws and rules governing the latter, and requires the disclosure of certain information by companies listed in the securities market. So in this case, the development of financial market necessitated the law that mandates certain disclosure by the companies. Another example would be, again, in the US in the 90s, the development of digital industry, digitalization, necessitated the law that approves electronic signature, which started to become prevalent under Uniform Electronic Transactions Act. So the law, in order to be effective, has to conform to the prevailing socioeconomic conditions, and also the change of socioeconomic conditions might bring up the change of law. So again, in order to assess the impact of law, one must look at regulatory design. And the design depends on the anticipated policy outcome, organization of LFIs, adaptability to socioeconomic conditions. Now, the second major element to assess the impact of law is regulatory compliance. The law will not be effective without due compliance by those who are subject to the mandates of law. In the context of law and development, regulatory compliance does not only mean the absence of rule violations, but also the knowledge of law and participation in the process mandated by law. So example would be the use of judicial courts. Now, there is no legal obligation to use the court for disputes. There are other ways to resolve the disputes, but the judicial court system will not be effective without meaningful use of the judicial courts by the populations. Regulatory compliance is affected by historical, economic, cultural, and political conditions. And these conditions, historical, economic, cultural, and political conditions, may not be immune to top-down attempts at reform. And some other conditions may be associated more directly with state action. Enforcement. Enforcement tends to attract or raise compliance, and this is more associated with direct state actions. Regulatory compliance is classified into general regulatory compliance. That's a general level of regulatory compliance in a given jurisdiction, how law in general is viewed in a society. The society, a particular society, takes law very seriously and not. And there is also specific regulatory compliance pertaining to a specific law. So general regulatory compliance is influenced by several factors. Legal culture affects general regulatory compliance. The legal culture of a society influences the manner in which the public perceives law and the degree to which they comply with it. Public knowledge and understanding also affects general regulatory compliance. So education is important in raising public knowledge and understanding, and the public trust in the government making laws but also affect general regulatory compliance. If the population has a stronger trust in the government, then obviously it'll actually increase the general regulatory compliance. Quality of law also matters. So well-designed, well-implemented law will attract stronger compliance. And enforcement, the general level of enforcement of law, is also relevant to general regulatory compliance. As for the specific regulatory compliance, the priority for enforcement will affect that. So if the government has a priority for enforcement of a certain law, then that particular law will attract stronger regulatory compliance. And it's relevant. The resource constraints and political will be relevant factors to determine the priority for the enforcement of a specific law. The specific regulatory compliance is also influenced by consistency with socioeconomic conditions on the ground. So, for example, a French law banning face covering in public places would face some resistance by the population whose religious mandate is not consistent with such a face covering. So in Muslim communities, this particular French law may not attract strong, specific regulatory compliance because of its inconsistency with socioeconomic conditions, in this case, religious belief on the ground. The specific regulatory compliance can also be classified into passive compliance and active compliance. Passive compliance is a minimal level of compliance with the requirements of law, primarily to avoid a penalty for a violation. So, with respect to the French law I've just exampled, those who may comply with the legal requirement might be motivated by the desire to avoid a legal penalty for violation, and that represents passive compliance. On the other hand, active compliance is the type of compliance that exceeds fulfilling the minimum requirements, seeking to assist the state in meeting a regulatory objective by actively participating in the process mandated by law, often with encouragement to others to do the same. So, in the process of economic development, the South Korean government back in the 60s through 80s emphasized the importance of using domestic products, domestically produced products, to support then the growing domestic Korean industries for economic development. There was a broad public consensus that it is important to comply with government laws and regulations that protect domestic industries to bring about overall economic development for everyone. So the members of the public not only meet the requirements of such laws, but they will actively participate in the process, often with encouragement to others to do the same. So active compliance, relevant to law and development discourse. There could be a national divide in specific regulatory compliance. So, for example, if there's a law that implements a free trade agreement, those who benefit from the FTA, such as importers, might encourage and actively comply with the requirements of the law, whereas the group of populations will stand to lose because of the free trade agreement, such as competing domestic producers, might resist. So in this national divide, a government may take a preference for the interest of its own economic policy. So if the government identifies its economic interest as a economic globalization, as promoting trade, if the government sees it, increase of trade as a national economic interest, then the government, despite this national divide, may choose to support active compliance with the laws that implements the FTA. The third major analytical category for the assessment of the impact of law would be quality of implementation. Implementation is the act of the state meeting the requirements of law and undertaking mandates under the terms of law to fulfill its objectives. So if a country set up a law that authorizes the government to grant subsidies to promote a particular industry, then the government has to act to fulfill the legal mandates by selecting beneficiary industries, determine the process to make those grants, and third, monitor its implementation, its application. All of this will be a state act of implementation of the law. The quality of implementation is measured by the extent to which a state meets the requirements set forth by the terms of law and fulfills the mandates under these terms, including its enforcement and monitoring terms. So going back to the previous example, the quality of implementation is the effectiveness and the degree by which the state was able to identify qualified industries, and then the transparency and effectiveness in making effective grants, and also the result, how those grants actually worked to facilitate and improve the industries, monitoring and enforcement. So cases of violations, omissions, and incomplete implementation, the part of the state count against the quality of implementation. So again, in the law that authorized the government to provide grants to industries, so corruptions, right? Failure to identify effective beneficiary industries, failure to make timely grants, and providing grants to otherwise unqualified beneficiaries due to corruption. All of this will count against the quality of implementation. So the factors such as corruption and incapacity of the state adversely affect implementation quality. Regulatory design and compliance affects implementation. So well-designed laws, the laws that attract strong compliance by the public, will have positive impact on state implementation of the law. Two factors determine the quality of implementation: state capacity and political will. State capacity means a state's financial, technological, and administrative capabilities, including internal controls against corruption, to implement the laws and fulfill the regulatory objectives. So going back to the example of grant to the industries, the state must have a financial resource to generate those grants. The state must have technological and admin capabilities to identify the beneficiary, the qualified industries, and means to effect actually making those grants in time and monitoring. All of this will be state capacity. Now, in the development history in East Asia, South Korea, Taiwan, and Singapore, there was insufficient state capacity, such as financial resources, insufficient financial resources. But in the case of South Korea, for example, insufficient state financial resources were augmented, complemented by human resources, well-educated government officials who are under Confucian traditional influence, willing and devoted to serve the government and nation. So some of the weak state capacity has been augmented by other areas of state capacity. So this is also often observed in the process of economic development in the past. There are some historic cases showing the importance of state capacity. So Germany, for example, in the 19th century, after unification, obviously German state capacity has substantially improved, which was translated into superior industrial and economic capacities toward the end of the 19th century. At the time, the Germany surpassed England in terms of economic and industrial capacity as a result of improved state capacity after unification, the strong state-led policies, economic policies, industrial policies in Germany have resulted in the success. Likewise, in the United States, after the Civil War, the US escaped the division of its own country, and the new reinforced union after Civil War was again translated into the reinforced industrial, the powers toward the end of the 19th century, and improved state capacity in the United States under inspiring leadership such as Abraham Lincoln were instrumental to economic and industrial development in the United States after the Civil War. So there are some cases that show the importance of state capacity in development. And also other countries like Chile and Spain, strong authoritarian leaders were able to mobilize the state capacity to enhance their economies, despite obviously the issues of authoritarian rule. It was undemocratic, but nonetheless, that reinforced state capacity under strong leadership in Chile and Spain arguably contributed to economic and industrial development in those countries. State capacity is an important element in development, but it's not everything, in a sense that there are cases of poorly designed laws as a result of political compromise in a state with otherwise high capacity. So in advanced countries with strong state capacity, there are laws that are not effectively implemented, primarily because those laws are poorly designed as a political compromise. The other important determinant factor in the quality of implementation will be political will. Political will is not a mere interest in development. It's the commitment and devotion of countries' political leadership to the implementation of law. So sustained political will instills consistency in regulatory implementation and enforcement where there is a political challenge. So for example, in a developing country with limited economic resource, there will be a substantial political pressure to make popular disbursement of limited economic resource. So the law that preserves and conserves those limited resources for long-term economic projects, such as facilitating industries, may not be popular among the general population because they cannot see immediate disbursement of those funds. So what's required in channeling those limited funds to long-term economic development will be a political will that can withstand the popular criticism, but showing devotion of a country's long-term development and to the implementation of law. So this challenge explains why authoritarian regimes in East Asia, again in the 60s through 80s, were able to bring up successful development. There is a difficulty with elective democracy. Elective democracy tends to cater to voters' immediate concerns, such as immediate disbursement of limited funds, rather than long-term strategic development plans that may require public sacrifice until the development potential materializes. Now, that doesn't mean that authoritarian rule or dictatorship are the answer. If it is, then the number of countries still under dictatorship and authoritarian rule should have showed economic progress, and that's not the case. So that represents indeterminate nature of the governance style that leads to development. No form of governance or government guarantees the generation of political will, consistent political will through decades, that is devoted to long-term economic development. So that's a challenge in finding political will in the midst of development. This concludes the first part of the Law and Development lecture, and we'll start again in the next lecture. Thank you.